Case number 21 CF 1848. May I have the appearances, please?
State by Leslie Basie and Zach Wichell.
Sir, please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and state for the record that I do not identify by the name stated.
The record should reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is appearing in jail attire today. The court is here to address a couple of things. Of course, the scheduling of sentencing. I also want to address a letter that was sent to the parties late last week on the 28th regarding the unsealing of search warrants, a filing from Mr. Brooks, and then an issue just as it relates to the record and the use of restraints during the trial, given a statement that was made by Mr. Brooks when the jury was coming out after they had reached their verdicts. So I'll start with the search warrant issue. The parties should have received the letter dated October 28th advising the parties that the court will be unsealing all of the search warrants tomorrow, November 1st, unless there's an objection that is raised. Of course, that's based in law and fact. And I indicated in that letter we would address any objections at this hearing. So I'll start with the state. Do you have any objection to that?
No, Your Honor.
All right, Mr. Brooks.
I have not received anything. I'm quite sure, or I don't know if you knew, but the very second that I left your courtroom Wednesday, Your Honor, I was placed on suicide watch. I was told that it was per jail administration, that it was policy, it was nothing I could do about it. They immediately took me right from court, stripped my cell. I talked to mental health. They changed me right over into the smock, and I was basically placed on that. They just gave me regular clothes maybe 10 minutes before I came to your courtroom, Your Honor. So I haven't. I wasn't allowed any mail.
We'll give it to you.
Huh?
I had the letter printed off, and we'll give it to you now so you can take a moment to review it. It really says everything that I just put on the record just now as well.
I accept for value in return for value this document. When was this letter? Because like I said, I've been on watch, so I haven't been able to obtain any mail whatsoever. Not from the courts, not personal mail, not anything.
So that was signed on Friday and then sent over. I'm not sure if it was emailed or if it was just delivered to the jail. I don't know if Madam Clerk has any information. It was done by my other clerk. But in any event, you have it before you. I had, at the request of the parties and with the consent of all parties, sealed or continued the seal on all of these documents, and the previous order indicated that everything would be unsealed either November 30th or at the conclusion of the jury trial, whichever came first. Of course, the jury trial is now concluded, even though the case hasn't gone to sentencing. So my intent would be to unseal everything tomorrow, unless you have an objection and it's based in law.
I have, like you said, this is my. I didn't even know that this was even sent over to the jail until right now, until you told me.
Understood. Do you have an objection to what I propose to do, sir?
I don't even understand. What do you mean by sealed and unsealed? I don't.
It would become a matter of the public record, and anyone could review those search warrants if they make a request.
Search warrants for what, property?
There's a number of search warrants that have been sealed as it relates to this case.
I don't see why they need to be unsealed at this point. Everything's pretty much been public already.
All right, well, I am going to unseal them effective tomorrow. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. An inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines the inmate to a small area with that table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public, and that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system, and it will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So.
Well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. There was no
shock device.
It was a shock device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered
I'm
up.
the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect the
of
ruling,
those
but it
as,
should be noted.
Your
it should be
objection is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact. It's a
not
fact.
sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to inquire about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee, so I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
Right,
public
Mr.
doesn't
Brooks,
deserve.
you're-
The public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And-
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
It's absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs.
Well, show
that will be
where's
part
the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be sealed. Why do they need
from
to be
public
sealed?
view.
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today, but
I
I need to
don't
move on
want
to
to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I had
right.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. that should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need to move on to
There's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why did I have a black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt.
on
That's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then. It's
Basie.
not going to stop the fact that they need
All right,
to know that the shock device
he's
is on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's
appropriate
fine.
findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shock device
Captain,
on
can
my
I
ankles.
please see you? We're off.
What?
Appearances are as they were before. Mr. Brooks, if you interrupt me, I will mute you so that I can make an adequate record regarding.
You don't need me anyway, Your Honor.
All right, he
You're gonna
interrupted.
need
I
me
will mute
anyway.
him. I need to make a record of his removal. The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions, and if he interrupted that process, he would be removed. He immediately interrupted that, and so the courtroom was closed. He was put into the other courtroom. He was audible for a little bit when I first went on the record, but he continued to be disruptive, and so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates, but that was not utilized in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table, and it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table, in this courtroom, despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in to speak, because we can't fit everyone in the courtroom at one time. And speaking with the families and the victims Wednesday after the verdict, I think there's a strong desire to have the sentencing before the anniversary of the parade incident.
Sir, I have unmuted you if you could speak to scheduling.
I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well. I haven't had the opportunity to speak with my representation over there because of the protocol that I've been on. If it pleases the court, if it pleases you, Your Honor, I would at least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm going to have the same representation at this point or if something's going to change with that.
Do you know the specific date that you're scheduled?
The 17th. That's for both cases. I don't know why they put both cases on the same date. And like I said, I don't know if anything's going to change between now and then. But both of those cases are scheduled to go to trial. And like I said, with the representation there, I don't know what's going to happen with that as of yet. There's been issues for months with that. I know that's something that Milwaukee has to deal with and not your court. But it would be a great help to me to at least be able to find out what I can find out about what can possibly happen there, and to also do any work that I may need to do on my end to prepare for that.
So I have looked at the dates. You are right. There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing, or I chose to go to sentencing on those dates. And it looks like, again, both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. The way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
Well, let's talk about a related issue, and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
I do.
All right.
I do.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate, there'd be 20 or more. Essentially, some people will be traveling to Wisconsin from different areas, different states. And I know they've expressed wanting to be there to speak for that. But like I said, me, myself, not being able to have the opportunity to speak with them personally, I haven't been able to reach out. Obviously, I can't reach out from where I'm at, collect call-wise. So I don't know what pleases you, Your Honor. I don't know what pleases the court, but I guess what I'm seeking is for enough time to know exactly who's going to be speaking, where they're going to be traveling from, and a little bit more information that I can provide to this court about the proceedings in Milwaukee County.
I understand your concern about the Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state said, I think it's going to take about a day to hear the remarks from the parties, and then I would come fresh the next day to give the court's sentencing. And so probably a day and a half, but I'd set aside both of those days just to be on the safe side. in case it takes a little bit longer for either of the parties to present their sentencing remarks.
Your Honor, I'm not interrupting.
Go ahead. Go ahead.
I was trying to make sure I didn't interrupt you.
Go ahead.
Your Honor, with all due respect, if it pleases if it pleases your court, Your Honor, because of my situation, I could benefit from a little bit more time. I'm not asking for something outrageous here. Just enough that I can tie up some of my loose ends, get you the information that you need to be able, if someone has to be present by Zoom or whatever the case may be, or to find out if these people are actually going to travel. And also still be able to prepare for what I need to prepare for, because obviously I still, regardless to anything, I still have to be prepared to continue court proceedings. I still have to be prepared. It will really, really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present what's needed to the court.
I understand that, sir. The issue the court has is, obviously, if I wait much longer than that, I would, out of respect for the victims, avoid the week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing. I mean, my calendar is just incredibly full. That puts us into January, and I'm not willing to do that. So I think I'm giving the parties ample time. I'm giving alternate ways for family members to speak, and that is by Zoom or in person, should they wish to be here in person. And no matter what, that would still clear Mr. Brooks to be in Milwaukee on the 17th. I mean, we're one county over. It's not unusual to do an order to produce that close.
What I was going to, oh, I'm sorry.
No, so I am going to schedule it for the 15th and the 16th. That's my decision on that. I want to just very briefly have, I believe it's going to be Deputy Kibler who's going to testify about the restraints.
Your Honor.
Yes.
Well, I'm not trying to interrupt.
Go ahead.
You said, when is this supposed to be? Because I'm definitely going to need a little bit more time than the 11th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Only those individuals who I specifically approve to appear by Zoom may be on the Zoom.
What if I'm placed on the protocol per the jail? What if?
Mr. Brooks, that's between you and the jail at this point. If there is something you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
They haven't done it for the past week when I went on a protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to have Detective Kibler come to the stand. Kibler.
Your Honor.
Deputy, what did I say? Detective, did I give you a promotion? Sorry. All right. He's going to come on up to the witness stand. I'm going to swear him in, and we'll go from there.
For the record, may I respectfully object to your ruling, Your Honor?
It's noted for the record. All right. Madam Clerk, swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr.
ruling,
Brooks,
Your
I'm going
Honor?
to have to mute you because I need to keep going and I can't have this disruption. All right, thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
Were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was, specifically, my responsibility was Darrell Brooks, along with Deputy Stengelson.
And were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
Do you have knowledge of the restraints that were utilized on Mr. Brooks
I
throughout
do.
this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
Sir, you indicated that the restraints were connected to the table through a tether, is that correct?
Correct, and then we would secure them with a padlock.
And how
on the
long was that
restraint.
tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up,
Correct.
he could walk to his left briefly and walk to his right, is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks.
Correct.
Okay, nothing further.
Mr. Brooks, you're muted. Do you have any questions regarding the restraint system as testified to by
Yes.
Deputy Kimber?
Yes, I do. And Your Honor, you can't practice law from the bench.
Your question, sir?
So none of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial?
Not that I'm aware of.
Not that you're aware of? Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stengelson putting them on, and I did not tell you that, nor did I ever hear Deputy Stengelson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial?
Correct.
And you never heard any deputy tell me that they were, matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
And what are those particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement, so if you did try to do anything, we would have had enough time to control you.
The prosecutors stated that the same rules were in effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer the question that was asked to the...
Mr. Brooks, I'm in charge of the record, not you, and the record's going to be accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right, Mr. Brooks, do you have any other questions for this
Yes, I
witness?
do. Yes,
All right,
I do.
it has
Before
to be
you start-
about the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you were not.
And so, how is it that the prosecution was able to do something that I was not able to do?
That's not for me to answer.
It's because of the shock device that was put on my ankles, correct?
There was no shock device on your ankle, sir.
I was told that it was. And you said that you don't recall hearing that being told to me, correct?
No, it was not told to you by me.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I've never asked you, correct?
You never asked me, but I also did not ever hear Deputy Danielson tell you that they were a shock device.
I never asked you. I never asked you, yes or no?
No, you did not.
So do you know for sure if I ever asked any other deputies?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankle?
No, I can't be for sure.
So how do you know I didn't ask?
You don't have to answer that. That's argumentative.
I mean...
All right, the record's been made. Mr. Brooks, I'm cutting off the questioning. I'm just muting him for a moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on Tuesday, November 15th. All right, thank you everyone. We are in recess. The court's going to take a short break before I start with my remaining afternoon calendar.